So good afternoon, everybody. My name's Andy Davis. I'm the Director of Research here at the Decent Criminal Justice Reform Centre. It's great to see everybody coming in. We're really excited to be hosting Amanda Izes and Alisa Smith today here to talk about misdemeanor waivers of counsel. They'll be presenting some of the work that they did in conjunction and collaboration with their colleague Sarah Stice. And the paper that was distributed to the registrants of this event earlier this week called Do You Understand? It's a fascinating paper. It speaks certainly to urgent policy matters related to the criminal process and defendants' participation and understanding of it, participation in and understanding of it. But it also speaks directly to some of the absolutely foremost issues of research concern here at the Decent Centre, because we're a centre that focuses, among other things, on early access to counsel for indigent defendants. As part of our Day One campaign, we're very concerned about the things that should happen in the very first day of a criminal case for a defendant. And one of those is that they should be considered for eligibility for appointed counsel, and they should receive two of those. The second is they should receive such counsel if they're eligible for it. Certainly my own research has focused very much on the dysfunction that can characterize some of these processes that courts have in place to get people access to counsel. But one thing that I've never been able to do is something that these researchers have done, which is that they've looked at the actual interactions between judges and defendants to find out the quality of the dialogue and the kinds of forms that actually administer this right in practice. And their analysis is a very important contribution to our understanding of how and when the system for actually accessing a lawyer breaks down. But I'm already characterizing their work for them, and so I'll stop doing that. I'm just speaking really to introduce while people are still coming into the room. This is one of our what we call our CJR, or Criminal Justice Reform talks here at the Decent Centre. This is a platform for people who have works in progress that are, again, germane to our research interests, but also represent kind of the bleeding edge and the most innovative and up-and-coming findings in the research in these areas. And we like to platform people like Dr. Izes and Dr. Smith, who are doing work that we're really pleased to see, and we just want to bask in the glow of and of what it is that you're doing here. So if anybody else on the call has work in progress that relate to our research interests here, which span not only the right to counsel, but also early decisions by prosecutors on charging in cases and the challenges of doing justice in rural areas, do get in touch. This is a platform where people who are doing really innovative work are most welcome. And in the meantime, I think now that it's 3 minutes past the hour, I hope that everybody who's here, who wants to be here, is here. I shall be coming back on when Dr. Izes and Dr. Smith are done speaking to moderate some questions. Please do save up your questions, because we're just on the cusp of being a relatively large group. I'll probably ask you to use the hand raise function in Zoom, which you can find under the React icon at the bottom of your screen. And so get ready to raise your hands, and then I'll call on you, and I'll invite you to unmute and speak your question. If you're not in a position to do so, you can type it and I'll speak it for you. But without further ado, I will pass over to Dr. Smith and Dr. Izes. Thank you very much.
Wonderful. Thank you. I am going to speak first, and Amanda is going to present the bulk of our work. First, I would like to thank the Decent Centre, Andy Davies, Blaine Skiles, and Divya for inviting us to present our work. We are excited to be here. For those of you who registered early, you got a copy of our unreleased report. Do you understand unrepresented and unknowing rights waivers by misdemeanor defendants? That work was supported with funding from the Bureau of Justice Assistance, and it was done in collaboration with the National Association of Criminal Defense Lawyers. Bonnie Hoffman was instrumental in helping us with that report. It is not for distribution, so that's why it has a draft on it, and they asked me to put the admonition on the front that it should not be distributed beyond this group for this presentation. We're hoping that it will be released soon. But for now, it is still in draft form. The presentation is titled, "There's Other People That Are Waiting That Will Probably Be Answering My Questions in a Little More Timely Manner, a comparative study of question and answer pairs, defendant resistance to procedural efficiency in misdemeanor arraignment hearings." Our presentation today is kind of two papers together, multiple papers together. It is the work we did with the National Association of Criminal Defense Lawyers, going over those findings that are highlighted in that future report. And also, it is at the end of this presentation, we are kind of looking at future directions based upon that work that Amanda is she has taken the lead on in this report. She has taken the lead on in those future ideas that we have for our next steps of research. And we're really hoping that at the end of this presentation that people not only ask questions, but give us suggestions and advice about where we should take this, what I think is important work. This work was done in collaboration with Sarah Stice, who is not joining us for this presentation, but she was instrumental in the writing, particularly of the Do You Understand report. We can go to the next slide, Amanda. The agenda is I'm probably doing some of the first one, and Amanda will be doing the rest of the presentation with the research questions, the methodology we use, the findings, conclusions, recommendations, and most importantly, I think for us, our future directions. Very, very briefly, there is some prior work that has been done in this area, and I won't belabor this background. Amanda will probably highlight and touch on some of it as she's presenting our findings, but there has been some prior linguistic research that has focused predominantly on Miranda warnings and people's knowing or unknowing waivers of their rights during police interrogations. There's also been some psychological research by Alison Redlick and others that have looked at people's understanding and comprehension of plea waivers. And they found that most people are not understanding. I think the statistic was in their research that 60% of people misunderstood their rights waivers and even maybe their outcomes. There's also been some other research in the 1980s by Douglas Maynard and a few others that looked at how the structure of language, the structure of the plea colloquy manifested in individuals automatically waiving their rights and pleading guilty. And there was also some research done in England and Wales by Francis Rock, most recently, I think he published in 2016, about tick box consent. So we're all familiar with waiving all of our rights when we're like signing contracts, and we just check boxes. Like when we get a new phone, we check boxes, and we're waiving all kinds of rights. And he basically found that that phenomena was going on also during police interrogations, that people were really just checking boxes to move forward, but they didn't really understand their rights waivers. So the focus of our research is on whether individuals are knowingly waiving their rights. This is a constitutional mandate that in order for individuals to plead guilty or waive counsel, they have to do so knowingly. The focus of our research really is on that first question about knowing waivers of counsel, and also the individuals we interviewed pled guilty. But whether individuals in misdemeanor court understood or knew the rights and the consequences of waiving those rights. Good. So our prior research and the research, what we're presenting today is part of a much larger research project. We worked on this for over 3 years. The first report that we published, and these are all available, these have been released They're on the NACDL landing page on misdemeanor waivers of counsel. The offstage and off-script report was based upon our observation research, our field research, where researchers sat in court and observed what was happening in court. And we looked at how bureaucratic due process was manifesting in these rights waivers. The second report with Dr. Madden was based upon administrative data, and we looked at case outcomes, and we found that delayed representation had negative consequences, particularly for individuals who were represented late by public defenders. And the third report was based upon our interviews with defendants who waived their right to counsel and pled guilty in misdemeanor courts. And we asked questions and developed a better understanding about why that happened, why they waived counsel. Let me turn the page. Next slide. The broad question here is to look at arraignment transcripts for the most part. We used a mixed methodology, as you can tell from the previous slide, and even for the presentation that Amanda is giving, we used mixed methodologies, but the core of what we looked at were the arraignment transcripts to analyze whether there were discourse structures that either encouraged or discouraged defendants from understanding their rights and waiving their rights. And with that, I will turn it over to my esteemed colleague, Amanda Izes, for the rest of our presentation.
Thank you. Great. So I'll start out on the same slide and then kind of move forward. I come to this question from a linguistics background. And as Professor Davies and Professor Smith have said already in this presentation, what really excites me about this kind of forensic linguistic approach is that it allows us to kind of drop directly into the action of these hearings. So while we have this research that Professor Smith mentioned showing that defendants leave their hearings not understanding what they've just waived or what they've just agreed to or the consequences of what's just happened to them, we have those measurements kind of from surveys and interviews after the fact, and this allows us to really dive in and see like how is this misunderstanding coming to be. And it's important to note before we move forward that because it's from a linguistics direction, linguistics doesn't allow us to read minds. So we're not trying to determine based on what defendants or judges have said, whether they're understanding in the moment or not. What we're really trying to observe and analyze here is kind of the behaviors that go on. So how judges ask questions, whether defendants ask questions, whether they express a need for clarification or confusion, and basically to get an understanding of how defendant comprehension is really managed within this arraignment hearing environment. To answer this question or begin to answer it, we examined two different pieces of data. One is looking at forms that defendants were given prior to the arraignment hearing. So looking at the application for the appointment of counsel form, as well as a rights waiver form, with the logic being that if a defendant can't read or understand these supplemental materials going into the hearing, they're already entering at a disadvantage in terms of knowing what they're waiving. And then the second portion was looking at transcribed arraignment hearings of unrepresented defendants to see what's happening during the hearing, how that conversation is going between judge and defendant. So first part, taking a look at legal documents. Just to begin super broadly, the background of this slide is actually the two forms that we analyzed. And just from a very kind of informal visual stance, you can see that these forms are very, very busy. And I like to kind of compare it to the age-old advice that we're given on resumes or CVs, that if something is too busy, people do not read it. And in this case, something very consequential is kind of filling the whole page with text. And then diving into more of the kind of specifics. So we would hope to see readability scores for these forms at or below the general population level, which is 6th to 8th grade. But what we found were higher than that. The request for appointed counsel form we found had a Fleisch-Kincaid readability score of about a 9th grade level, while the rights waiver form had a score of about 13th grade or early college. So basically, if defendants come in only being able to read at a 6th to 8th grade level, we can't assume that these forms were ever fully understood, even if they were signed, or even if the defendants stated that they understood them. And then kind of digging into the more granular pieces, we can see that there was use of ambiguous words. So things like waive versus waive can be confused, as well as the use of difficult words that aren't ordinarily in use. So things like the meaning of indigent. And then another kind of category is words like appointment that have informal meanings, but can take on more specialized meaning in a legal setting. Then there was the use of complex or convoluted sentence structures. Most prominently is kind of the use of the conditional form, where you have a hypothetical being pulled in, and it requires multiple stages of logic to understand. And then finally, the use of legal references. So kind of referencing section 775.082 is not an understandable kind of referent to anyone who's not a legal expert, and even legal experts themselves. As Professor Smith mentioned, and as we'll kind of bring up throughout the rest of the presentation, these features are not unique to these forms only. These kind of use of ambiguous words, complex sentence structure, does come up in research that's been done on Mirandization and kind of interrogations, with the use of particularly like embedded clauses and ambiguous words. And yeah, so, and importantly, as we move on, the judges do rely on these forms as a means for education and kind of comprehension check for defendants. So throughout these hearings, and particularly during the plea colloquies, there will be references to them for things like, you understand the rights as you read them, right? Or recognize these forms. So the fact that it's not trivial that these forms are difficult to read, that they are kind of a sole source of information that defendants received, and that are then used again in a consequential part of the hearings. So with this kind of overview of how defendants may be set up before beginning their hearing, we moved into asking, what does a hearing typically look like? And to do this, we use genre analysis. Genre, as you probably understand it colloquially, is defined as a class of communicative events having a shared set of communicative purposes and similar structures. So it can be something as informal as how to order takeout food, or speak with a colleague, or give a presentation, or in this case, an arraignment hearing, specifically for unrepresented defendants. And just to the broadest of overviews of how genre analysis works, it's a very inductive analytical process where you kind of have exposure to the genre, determine what key characteristics might exist, get additional exposure, kind of adjust that structure. And as you continue adding more, you can refine that structure down to kind of what are the required steps and what are optional. So for misdemeanor hearings, we can see that we found the structure for unrepresented defendants can be broken down into 5 moves. I won't go through all of the details, but happy to discuss them, all of the steps, but happy to discuss them after the presentation. Just don't want to drag you through that. But the 5 main moves are judicial introduction. So the judge identifies themselves, the defendant, the plea offer, then the defendant plea, entering guilty, not guilty, no contest. Then the plea colloquy, which we'll focus on next, and then finally judicial closing, which kind of acts as a summary and reiteration of the first 4 steps or moves, first 4 moves, sorry. So as you can kind of see here, the structure's quite rigid, and as we'll kind of go through more in the next few slides, as well as future directions, this rigid structure really does become kind of a catalyst for the discouragement of comprehension seeking behavior, so asking questions or answering questions for the judge. So to get kind of dig into that more deeply and get a better idea of what the structure means for defendants knowingly waiving their rights, we examined arraignment hearings using, and the specific content within arraignment hearings using conversation analysis. With the structure we identified from genre analysis as kind of a guide for what is typical. So basically asking the question, how are judges and defendants interacting in kind of a scripted way that encourages or discourages comprehension? So just a brief overview of conversation analysis. Conversation analysis and critical discourse analysis aim to describe how talk makes things happen. So how it either creates or maintains social structures, power dynamics, the coordination of actions, coordination of events, etc. And typically when conducting conversation analysis, you focus on specific speech acts or things or units of language that make things happen very broadly. In this case, we focus on question and answer pairs because of how prominent they are within hearings and kind of within court discourse in general. Typically, we refer to them as adjacency pairs because they always kind of occur together. Someone asks a question, the appropriate response is to answer. So for this presentation, I'll be focusing mainly on that plea colloquy move and what we identified as patterns within there. So first, we found that once a plea is made or entered, each judge entered into a nearly identical series of yes or no questions that in theory were designed to confirm defendant's comprehension. As you can see here, this is basically like your most model example of what a plea colloquy looks like. There's a series of questions that are either closed or have yes or no. So things like, is this your signature? Do you understand your rights? Are you doing this voluntarily, et cetera, et cetera? And in kind of an ideal world, perfect world, the defendant answers each question yes or no, and doesn't expand beyond that. In the majority of the time, defendants do respond sticking within kind of what is appropriate. So with yes or no answers. So importantly, that is caused because yes or no questions limit the way in which defendants can respond appropriately. But when the defendant did attempt to expand beyond yes or no in this questioning process, we see that the judge, even in these cases, quickly tries to return to that expected path of conversation, that expected model of question, yes or no, question, yes or no. So in this example, you can see that the defendant attempts to correct the judge after the judge says, if you're not a citizen, you could be deported. The defendant tries to say, I'm an American citizen, so, and is immediately interrupted back, where the judge tells the defendant that the deviation isn't necessary by saying, I figured you are, but the law says I got to tell everybody just in case. And in this example, one of the key things that we kind of pulled out was that it gives a bit of insight and kind of ignites the question of how routine really defines the arraignment hearing process, rather than it being driven even slightly by a need for defendants to fully comprehend what they're waiving. And kind of the idea that this script that they're following is not for the defendant's benefit, but it more kind of protects the judge, so the plea is not reversed on appeal, so that, as Professor Smith mentioned, it's kind of like tick box checking things off. And you can see that interruptions are kind of common in this course correction. And then finally, when this kind of deviation from the script moves beyond just a comment to a question, judges tend to give inadequate responses in their path to kind of returning to the script. So in this example, the judge presents the defendant, Marcus, with the expected questioning of his plea. And instead of immediately responding, as we've seen in the first example I showed, Marcus responds by saying, what's the difference? And the judge responds pretty concisely, saying guilty means I did it and no contest means I just want to resolve it. While this answer is felicitous and appropriate in kind of its syntax and content. It's arguably inaccurate in that it's very oversimplified. So oversimplifying the meaning and potential repercussions of a no context plea, this response potentially gives Marcus a false sense of understanding of what he's actually kind of agreeing to by entering a plea of no contest. But because no explicit questioning of understanding from the judge to Marcus occurs before Marcus's response, which is entering the no contest plea, the judge has no way of knowing, and we have no way of knowing with certainty, that this defendant fully understands his rights or what he's waiving or the consequences of what he's just entered. So with that kind of little taste of what we found, we see that the findings so far in this report parallel a lot of other interactions in the legal system that have already been analyzed through a linguistic lens. So we see very clear preference for yes or no questions in evaluating understanding, and if not yes or no questions, closed questions that rely on kind of two alternative options or three, where it's guilty, no contest, not guilty. And secondly, we see that there is this very strong preference for adhering to scripted language, likely to promote kind of efficiency rather than giving thorough, meaningful responses to defendants. So because these findings are so similar to previous research in the process of Mirandization and interrogation, we've argued that some recommendations should probably mimic the guidelines suggested for these processes, as they've shown some success. So, for example, one recommendation would be to allow defendants kind of explicit state to restate the meaning of their charges and what they believe the waiver of rights to be. This recommendation has already been supported to improve comprehension in the Mirandizing process, as I said. And other kind of recommendations that we've thrown out have been employing plain language and removing the complex grammar and vocabulary to try to improve readability. Again, this has been done in Miranda rights as well as kind of jury forms, jury instructions. We could also talk about restyling rights waivers into kind of rights advisement questions, moving away from that, relying on these complex forms. And then finally, and most broadly, kind of moving judicial discourse away from closed-ended questioning that kind of corners defendants into single word responses. So changing the structure so that there is inherently more space for a defendant voice. So with all of that in mind, we kind of take our findings of this basic structure and its effects on defendants into future directions and new questions that it's brought up. So right now, our questions kind of fall into two broader categories. And we'll show you, I'll go through kind of some of our observations, but we're really happy to discuss this further with you as they're in their early stages. So basically, as I said, we have this structure that we've built. What does the structure of an arraignment hearing look like? And kind of how does that work to ultimately discourage defendants from comprehending their rights entirely, or being able to even act towards comprehending their rights? These questions deal more with wanting to gain a more nuanced understanding of what happens in each piece of that structure, and when acting within this structure, what other behaviors might be going on that affect defendant comprehension. So first question, moving beyond basics of question structure to rhetorical tools like lexical choice, speech pace, question sequencing. How do judges communicate to and interact with their defendants beyond just question type? And how might this affect defendant behavior? And then secondly, as we saw small bits of in the second and third examples of our report, when a judge's conversational agenda is disrupted, what happens? And how does that change depending on how much disruption is kind of introduced? So our first observation is basically judges regularly communicate consequential information using complex sentence and paragraph structure. Here you can see this is one turn that a judge has taken in an arraignment hearing. It's very long. It's not his only turn throughout the hearing. And essentially this entire turn is a summary of kind of, if you plea, what you'll have to do. If you don't follow through with what you have to do in terms of paying fines, these are the consequences, and kind of the nitty-gritty within that. You can see in this first slide that throughout this whole kind of monologue, there are 2 questions asked. The first is okay in the middle, which you could argue is an attempt to kind of check defendant comprehension, but that's kind of immediately overturned by the fact that the judge continues speaking afterwards. And then the second, which is now, did you wish to have a formal hearing on the speeding ticket, or did you wish to plea no contest? So here we see the question is a kind of a direct map back to that plea colloquy, or the defendant plea move in the structure. So immediately kind of mapping back to that structure that they stick to. But it's not only that there are only 2 questions asked, we also see that all the other information in this is kind of shrouded in complex syntax and structure. So kind of going through this step by step. In blue, you see all of the sentences that describe some sort of consequence in the form of a conditional complex sentence. So a bunch of if-thens, a bunch of hypotheticals. Then you move on to see, in addition to those conditional sentences, these are compound sentences that are also a form of complex sentence that combine 2 clauses at once. And finally, you add in more complex sentences that have more than 1 clause. And you can see that this entire monologue, not only is it long and would be too much for anyone to actually remember, it's also kind of entirely created with complex sentences that even in isolation are difficult to follow. Then adding on to this, we see that judges often are kind of non-standardized in their pacing. When we move into particularly very routinized moves like the plea colloquy, we see that judges tend to speed up when they're kind of saying these terms. So then you get this combination of these complex sentences like if-then, often if-then, as you can see in this example, being spoken to the defendant in a very rapid pace. And kind of as an aside that we haven't dug into that much, but has been an interesting observation, is that when you are dealing with hearings where an interpreter is used, we don't see this speeding up process. So it's an interesting point of comparison, as well as kind of just a point that highlights that this speeding up and this complexity of language is not necessary. And it is possible for judges to conduct these hearings without employing these behaviors. And then finally, moving on to our kind of second thematic question, what does defendant resistance look like to this like established risk? What does it look like, and how do judges respond? So the example below is one of the more extreme examples that we've come across, where the defendant really just does not provide kind of the appropriate accepted answers at all throughout the hearing. So just for kind of color coding, the pink is the judge. Anytime the judge tries to return back into one of the clear moves within the structure, which typically in this case is the defendant plea, and orange is whenever the defendant represents some kind of resistance, which we've kind of standardized thus far as not responding in the felicitous way. So for example, in the first line, did you wish to plead guilty or not guilty? The appropriate answer would be guilty or not guilty. But the defendant instead says, I actually wanted to present that I did pay, to which the judge responds immediately with correction back to the script. Today's not your day to have trial. Today is simply for you to tell me whether you want to plead guilty or not guilty. Again, the defendant kind of pushes back, and the judge repeats again, but basically verbatim back to the move, guilty or not guilty. And again, it happens that the defendant continues to not respond as is felicitous appropriate. Then we kind of move further down in this hearing, and the same thing just keeps happening in these pairs of pink and orange. to the point where eventually you get to the defendant showing obvious signs of frustration with kind of a heavy breath out, a heavy sigh, and then the judge taking away his ability to kind of answer. The judge narrows the question even further, going from a closed question to a yes or no question, saying, I think you already said you wish to plead guilty, not guilty. Is that correct? And when the defendant, again, does not answer the question, the judge kind of expands the correction to the resistance to not only this individual, but kind of making an example of this individual talking to the entire courtroom, saying there's other people that are waiting that will probably answer in a more timely manner. Have a seat and don't leave the courtroom. So essentially kind of sends him away while amplifying the correction to not only an individual experience, but a group experience. And we find that kind of social pressure that comes with the exacerbating effect of resistance really interesting, and something that we'd like to explore more. So kind of to sum up all that information and transcripts, because I know it's a lot of words when you're looking at transcripts. Our kind of key observations so far have been that judges regularly communicate consequential information using complex sentence and paragraph structure. Pacing in this case plays an exacerbating role in this complexity, but also, as we've said, can act as an insight for the fact that there is potential for change of this behavior, of these behaviors. And then we see that defendant resistance is consistently met with kind of judicial adherence to structure. And we can see that through judicially repeated phrases, so guilty or not guilty in this case, as well as conversational expansion to the entire courtroom, or kind of very informally making an example of a defendant for other people waiting for their arraignment hearings. And these are references. And yes, so thank you so much for listening. And yeah, we are excited to hear kind of your feedback of where we're going, where we've been, where you guys have been. So thank you for listening.
Thank you, Amanda and Alisa. So as promised, I am interested now to moderate folks' questions. Please do stick your hand up if you have one. That was extremely informative, and certainly my mind is abuzz, so I expect that other people will want to weigh in as well. I have questions and I will ask them, but that's very boring for me. So I'm asking audience members to come in and ask your own as well. I'm trying to resist the sort of what I think might be the slightly more depressing implications of the paper, which is that this is a system that constantly sort of corrects for any attempt to actually sort of use it. And also a system that has nothing to do with knowing and voluntariness at all. I'm actually reminded of a fun story about an internet security provider that had its users check a box volunteering to give their firstborn child to the internet security provider, and 6 people did it. So this kind of, burying things in legalese is a very effective strategy indeed. But I was especially interested, therefore, in the sort of what I took to be the what do you call it, the deviant case analysis of the defendant who actually did try and speak up. And I think that my questions are sort of, there are just 3 of the same question, which is, what advice would you give to defendants in this situation? What advice would you give to judges? And what advice would you give to policymakers? But I want to hand it over to Malia because she has a question also. Go ahead, Malia. We don't hear you. I see you're unmuted, but we don't hear you.
Okay, let me.
Oh, there you are.
Okay. Okay. Can you hear me okay?
Yes.
All right, perfect. Sorry about that. My question concerned video explainers, which were referenced in some of the exemplars. And one way to control for language level of explanation is obviously to record something that hits those cues. But on the other hand, I feel like those are sort of commonly ignored. And I was wondering if you ended up kind of coming to any part of the kind of policy conclusions that Andy asked for that revolved around whether those are more useful or not, whether they're useful only in conjunction with things as like a reinforcement mechanism, or anything you had on that subject.
Yeah. Amanda, do you want me to take that or do you want to answer? Do you want me to-
You can go if you want. Yeah.
Okay. I mean, and then you can just piggyback.
Yeah.
Well, I will tell you, Malia, that in our observation report, that was one of the interesting findings. We looked at two different jurisdictions. One was a larger county and the other was a smaller county. In the larger county, they didn't use videos often. They did once in a while. Often, though, when they did, they were only in English, not in Spanish or any other language. So we also found that there were a lot of language difficulties with regard to how people were being communicated with. In the smaller county where they did use the video religiously, really, it was every court hearing they played it. We found a couple of things. One, they were supposed to, in one courtroom, they were supposed to watch it before they walked into court. And what our field researchers saw was that people just walked on by and never stopped to watch the video. And in the other courtroom, they played it while the public defenders were circulating in the room and people were talking, and they observed that most people were not watching the video. So even if the videos might be useful, there has to be a way to not only make them more accessible, but ensure that individuals are watching them. The third thing I'll say about the videos, at least the videos that were being utilized in these courts, particularly the smaller county, is that they kind of merged information. They kind of like put on the same playing field your rights and what an arraignment was. Most people didn't even know what arraignment was. Your rights alongside of kind of the procedural things in court, like do not chew gum, take your hat off, sit and be quiet. So these things were all like merged together as if they were equally important. And so I think that very few people really tuned in were positively affected by the videos.
Thank you. I see James Hufjan has his hand up also. Please, go ahead.
Hey, thank you for your work. I'm a public defender. I've been a public defender for almost 8 years now in Louisiana and Maine. So your findings come as no surprise to me, right? It's like one of the worst kept secrets in the legal system is that these kind of almost every kind of colloquy is really designed to protect the judge and not to help the defendant better understand. And in fact, I think they're designed to do that. So have you had much success with judges actually looking and saying, oh, I actually do want people to better understand. I know it might take some more time, but I'm okay with that.
Amanda, you've read all 26 of our arraignment transcripts. Did you think any judges did a good job in trying to ensure comprehension?
Yeah, I completely agree with what you're saying. We've seen cases, particularly in butter, I'm thinking of, there are cases where when something out of the ordinary is happening. So for example, in this butter is the pseudonym case, the no offer has been created. The case the charge hasn't been kind of entered yet. So there's a strange case where it does seem that the judge feels more compelled to explain each step. We also see that when interpreters are involved, there does seem to be more, at least awareness of the language being used. So maybe not perfectly kind of explaining, because it does seem like efficiency is kind of ground into them as you learn how to be a judge in these cases. But there are kind of atypical instances where you see the possibility of judges caring more about thoroughness in terms of educating.
Yeah. It just takes more time.
Yeah,
takes-
which is definitely a roadblock in kind of, I think that as we've discussed, kind of a hope for the kind of so what of this work is kind of within the education realm of being able to at least show and make judges aware that this is happening and the effect that it has on it. But it is definitely kind of an obstacle to get past the pressure of efficiency.
Yeah. You know, going back to Malia's question, and I would love to hear if she has any ideas, you know, I don't know if there's a way to combine the efficiency that the court so desperately wants, which I think is unnecessary. Like, so many of them are rushing to, I don't know what they're going to do, go back to their office. Like, like they don't even have, I didn't even see very large, when I sat in the courtrooms, there weren't lots of people in these courtrooms, but they were still rushing. It didn't slow anything down. But I didn't know if maybe we can create a QR code or a, not to infantilize, but something that was a little bit more simple, like a cartoon that was something that was more interesting, that could educate people in a way before they're in court, before they're in this stressful situation. Because that's the other thing with the complex decisions report, is that these people are stressed out. They're coming into court, there's bailiffs, police officers there, there's a room full of people, even though it's not a lot of people in my mind, it's still other people. They're standing up in front of an audience, you know, and then they're being told their rights, even if it's by video or by the judge telling them their rights. I mean, they've got so much going on. I don't know if there's a better way of imparting this information, because it seems what's happening in court, whether it's the documents, the conversation, the videos, it's not working.
Yeah, Alisa, to answer your question, sorry,
Go ahead.
your question, I think it's an interesting idea to have something tied to court reminders. So, you know, to your point about by the time you get there, right? If you are showing up for an arraignment, and this is, you know, apart from it, and in addition to what Bob is saying in chat, I really feel like it would be a good start. I mean, because I think you need to hear it more than one time. You need to hear it in general and in specific. And for the general piece, I think there is something really lovely about being able to prepare and know everybody heard the same thing. And if you could make something interesting that just explained what these types of hearings were, that went with the court reminder. So like if the court reminder says, you know, text reminder says you have a, you know, hearing on this date, to find out more about this hearing, click here. And then you had a like brief explanation of what a bail hearing is and what's going to happen. Like, I don't know how effective it would be, but it can't possibly hurt.
Yes, you're right. It can't hurt. Yeah.
I want to also couldn't agree more with any of the direction of this, but also particularly on Bob's point, and Bob, perhaps you want to say a little bit more about it. You know, my appreciation of the application process that you described, where they're asking for income information, is that I have a lot of thoughts about application processes, and I've always wondered if they're really necessary. But as I appreciate it, they do at least two things. The first is that they ask if you're really eligible for a lawyer at all, and the second is that they actually verify that you want one, because you have some Faretta right that I don't probably understand, where you can decide not to have one. But as I appreciate it, there's nothing about any of that that stops you simply having a lawyer available to advise somebody. And furthermore, what we know is, and there are jurisdictions that are experimenting with this now, as I appreciate it, some interesting law just made in North Dakota on this. But certainly, you know, there are cafe experiments, counsel at first appearance experiences that have been going on in quite a lot of places. And the finding seems to be, among other things, to your earlier point, Alisa, that first appearances go better. Because if defendants are coming in and a defender, whether they're the appointed defender or just some sort of advisor who's hanging out available for consultation, is able to organize with you your thoughts about, your ties to the community and so on. Like, we got to deal with bail today. Like, you're not going to just go up and, as some of the defendants are doing in your sample, trying to talk to the judge directly and just getting shut down so badly. And I've seen it, it's so painful. And there is such an unequal contest. The defendant cannot speak for themselves effectively at that point. It's no surprise that that's so ineffective. But advisement by a defender who may, without going through an appointment process necessarily, and then maybe, of course, that defender does become the appointed lawyer as well. Isn't that something, you didn't observe it in your jurisdictions, as I appreciate it, but isn't it something that might make the system work more efficiently and also allow us to have a bit more confidence that defendants knew what they were doing before they were going in? And Bob, you may have things to add to that.
If Bob wants to chime in, he can chime in. I will tell you that in the small county, we did see some version of that. The public defenders, the large county, we did not, but in the small county, they circulated before the judge took the bench while the video was playing, and did speak to individuals and gave them their forms, but they only had a few minutes. So I'm not sure whether they had that would be considered adequate or not. We didn't really see very many differences in terms of case outcomes and waivers. In the case that Amanda highlighted just now, where the client was wanting to resolve his case, or he wanted to talk about his case. I don't know if you saw on the screen, but at one point, the public defender actually wanted to intercede. He said, Your Honor, and the judge immediately said no. And the thing the underlining that Amanda did in these transcripts was the judge getting louder and louder. And he cut him off, and he did not want the public defender to, I know exactly what he was going to say. He was going to say, Your Honor, as a friend of the court, can I speak to him? And he shut him down. So I think it would go a long way if people had adequate time. I think Bob did unmute, so I'll let him speak.
Thank you, and thanks for the presentation. I missed most of it because I was elsewhere, but I just want to say I appreciate what you're doing, and the language analysis and the closed questions and yes or no. The reality is many misdemeanor courts express a contempt for poor people and a disregard for the right to counsel. And a lot of these judges learned how to do it from other judges who have the same contempt, and they just say, okay, we want to be efficient. That's not what it's supposed to be about. It's supposed to be, people are supposed to be understanding their rights. Asking them, do you understand your rights, is a ridiculous question. And they simply should have lawyers. Everybody should have a lawyer to explain to them what's going on. They don't understand the consequences of the plea. The prosecutor tells them, you're going to either get out now or we're not going to put you in jail if you plead guilty. And no contest is the same thing. The immigration consequences, they don't even understand. And they don't understand that they can get revoked on probation later for not doing all these things that they're supposed to do that they can't do because they're homeless and they have mental illness and they have drug addiction. And it's just, these courts, as Malia knows really well, are horrible. And in these places that you found where the judges act like this, they ought to be shut down until they can provide lawyers. And I guess to the extent that you feel comfortable saying that in any of the presentations you make or articles you write, I think it's important to say that it's not just a question of analyzing the language. It's a question of the culture of these courts. And the public defender, if he gets shut down, the public defender should say, wait a minute, judge, and keep talking. I mean, I did that once in a court, and it turned out that the police officer there was helping to get the client, it wasn't a client, the accused person, a hearing the next day when the public defender would be there. And it's just so awful in these courts, and it's so important what you're documenting. And if you can add to it some dimension of this has got to stop and there's got to be lawyers, that would be really helpful. Thank you.
Yeah. I mean, what we did see is, even with this one case that Amanda highlighted, that they don't really make many inquiries. They accept a guilty plea. In fact, in many cases, I mean, I don't know if you counted them, Amanda, but like the first question is, do you want to plead guilty? No, no contest, or not guilty. I don't think that's the order. I think it was the other way around, but that's the first question. It's not, do you want a lawyer? The first question is not, do you want a lawyer? In fact, they only start asking about a lawyers when they want to plead not guilty. And if they don't have a lawyer, then they get concerned. Then they're forever concerned because they're like, I don't want to have a trial with a defendant who doesn't have a lawyer. Taking a plea, that's fine. You know? So anyway, I think Allison Redlick has her hand up. I don't know if Amanda, you
Go
want
ahead,
to add?
Allison, please.
Thank you so much. That was a really, really interesting presentation. And I'm going to ask you a question that I often get asked, and I really hate this question, but I'm kind of curious to hear your answer. So I'm commonly asked, you know, does it make a difference? Would people plead differently if they knew, if they understood all their rights? I agree with everything that everybody is saying with the findings of your research, that, you know, I'm convinced that most defendants are not making knowing, intelligent, and voluntary plea decisions. And if there was some kind of way to ensure that they really did understand all of their rights, would it make a difference? Would they make a different plea decision?
Yes.
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 What do you think, Amanda?
I mean, I think it is a really hard question because you're kind of entering into the hypothetical. And I guess my immediate response is we won't know until we do make these changes, and whether they make a different decision or not doesn't change the fact that individuals deserve access to the materials needed to enter knowing, voluntary, and intelligent pleas. So yeah, I feel like, yeah, the step is still necessary. And then if they still make the same decision, at least it's being made after due process.
Yeah. And I do think that even if it only changes a small percentage of the individuals, I think that's important. You know, what's ironic is about this case we'll call Jones, you know, where they went back and forth. What the judge did is he made him sit down, he got back up, and he didn't let him say a single word. He entered into a not guilty plea form, so he had to come back to court. I looked up his case. He missed court. So he was in custody and he pled guilty. So this individual who was asserting his innocence ended up pleading guilty. And we didn't interview him, but I would bet you $100 that he pled guilty because they said, great, you can plead not guilty and you'll have your trial. It'll be several weeks, months from now, and you'll sit in custody waiting for that outcome. And he never had a lawyer. I mean, he ended up getting a lawyer at that point, and he pled. So I think that could have stopped. I think that individual, had he had counsel at that first appearance at arraignment, they could have gotten his evidence. He had documents. More could have been done with that one individual. And, you know, we're talking about the misdemeanor court proceedings. So a lot of these individuals are proceeding without any guidance at all. So a lot of them don't, when we interviewed them afterwards, which is the separate report that hasn't come out yet, we have a report on consequences. We interviewed people over 6 months afterwards. Many of them did not understand the consequences. They didn't understand what the expectations were, what would happen if they failed to pay their fines and they got their licenses suspended. You know, there are these long-term consequences that are not taken seriously by our system that really affect people's lives. As Bob pointed out, there are now there's huge deportation consequences. But a lot of these individuals lose their license and then they lose their livelihood, and it devolves.
Yeah, no, absolutely. I agree. No, like I said, very interesting research. Gave me lots of good ideas. Thank you.
And if I could answer your question, I think based on courts I've observed and the work that Douglas Colbert has done and the other studies that Andy mentioned, there's no question having a lawyer makes a huge difference. And I'll just give you one example. In courts that I've worked with in Seattle and the city of Edmonds, the dismissal rate is between 25 and 50% when people have lawyers. So you've got hundreds, thousands of people pleading guilty to cases that would have been dismissed if they'd had a lawyer. To me, that's the answer to the question. And it absolutely makes a difference because the client has the non-client has no idea what the merits of the case are, and the prosecutor's running over them because they don't have a lawyer. And
I absolutely agree. I absolutely agree. Just to clarify what I was asking about, that was certainly people who need lawyers and it shouldn't be waivable. But I was talking more about the colloquy and the rights questions, and if people understood their rights that they were giving up, would they make a different plea decision?
The federal courts, and I haven't checked lately, but one of my colleagues years ago was charged with a crime in federal court. It was eventually dismissed. He was an experienced criminal defense lawyer. I was in court with him, and he had an experienced defense lawyer representing him. All the judge was doing was arraigning him, and the judge took 10 minutes to do it. So that's what, misdemeanor courts don't do that, but if they did, it would make a difference. People would have some glimmer of understanding, and they would say, you know what, I think maybe I should get a lawyer and see what I should do. I apologize, I've got to run to the airport, but I enjoyed this discussion. Thank you for letting me participate.
Thank you.
Thank you.
Thank you, Barbara. Thank you, Alison. Go ahead,
Alison,
Lee.
I think that's a good point, Alison, and I hope maybe that's what your future research is on, about whether changing the colloquy does have an effect. And if your research is going to be on that, if I can add to that.
Sure, of course.
So if I can,
It's not, but yeah, it's a good idea.
It's a great idea. But if you can also broaden it to the immediate effect of whether it changes their decision and maybe whether it affects their view of the courts, because what we're also finding is that there's such an alienation and estrangement from the courts when we interview these individuals. They just don't think the system is built for them. There's just so much resignation and alienation, and there's another word I can't think of right now, antagonism. And so and maybe I'm naive, but I would think if the judges would take just a little bit more time and lawyers would take a little bit more time, there's a lot of distrust of public defenders. Maybe if we all took a little bit more time, that maybe it wouldn't change the immediate outcome of whether they pled, but it might have a better long-term effect on the legitimacy of our system.
Oh, it was really, I told you, like a question I usually get, but it was more devil's advocate. I agree with you. Yes.
So you can study that next.
Okay.
From a psychological
We're going to study it together.
Great. I love that. You know that.
So while we're giving out assignments, no, I appreciate that we're after the hour. So thank you for everybody's time. I've taken an awful lot away from this. I'm very, very thankful for it. Thank you very much. My thought is that there are always outputs and outcomes and impacts, right? And the impact might be to change the view of the system. The outcome might be to change the view of to change the likelihood of the person pleads guilty. But also let's not forget one of the things you were studying was whether people actually apply for counsel. And we see in Texas misdemeanor courts, there are some courts where nobody applies for counsel, and there are some courts where everybody applies for counsel. And every statistical model that I run on it can't really explain the variation. I think that the variation is because of the interaction people have. And so while you may not be able to change the likelihood that people plead, I think that if you change these colloquies and you change these forms and they change these processes, you could certainly and absolutely directly change the likelihood that people are represented by a lawyer, the likelihood people actually even seeking to be represented by a lawyer. I'm convinced it's completely a product of these interactions. And that is an example of an output which might result in the other outcomes. So I'm extremely stimulated and excited by your work. I also want to be a part of any evaluation that changes and experiments with different procedures and traces the impact of those. But in the meantime, thank you everybody who came. Thank you especially to Alisa and Amanda. And I'll leave you guys to have the last word.
Go ahead, Amanda.
Just thank you all for listening. Professor Davies gave me a promotion, but I'm just entering a PhD program in the fall. So I'm very excited to kind of be joining this network of scholarship. So thank you so much for allowing me to present. Pass it over.
Yeah, and thank you everyone for attending and listening and being interested in this work. And if you have any ideas or suggestions based upon this presentation or the paper that was distributed, please don't hesitate to reach out. I will say, look for Amanda in the future. She is going places, and it has been a delight to work with her. This was by and large her work. So thank you, everyone. And thank the Decent Center. Thank you.
Thank you all again. See you soon. Bye-bye.